Hello everybody, welcome back to Law Hero. My name is Jen and this is the 2022 FE1 synopsis, subject by subject video. I've been doing this now for 4 years. This is year 4, I can't believe it. Do you think I've aged? You can put it in the comments if you think I've aged or not. But yeah, I've been doing this for so long now, it is crazy. And of course, I'm going to start off with company law being my favourite subject. I always say to you guys with the FE1, start with your favourite subject, so I'm following my own rule. If you need some additional help, please go onto my website, lawhero.eu. Follow along at lawheroirl on Instagram or email me info@lawhero.eu. So today we're looking at company law, and this is how to pass company law 2022. And we're gonna use the exam reports from October and March 2021 as a kind of a guide around what the examiner is looking for. But basically I will kind of give you in this video 8 points on how to pass company law. I have done copious amounts of videos around every single FE1 subject, and year on year I just kind of build on that. So I would recommend to watch the other videos. And here we go. So the first issue I would like to point out is that in October 2021, Tom Courtney actually failed more people than he passed. More people. Tom Courtney failed more people than he passed. And I myself know that Tom Courtney is a wonderful person, and I suspect the reason for the failing of over 50% of candidates is because he is a very fair marker and he doesn't like when people don't do the work. Let me explain. His paper isn't predictable, but the questions he asks are, and indeed he is the examiner known by far to repeat questions. So let me repeat that again. He repeats questions. You will see, for example, in October he asked questions from 2 Octobers ago, and it's in a way, if you have 8 topics for company law, it's predictable how they will be asked, which gives one a great advantage. For example, I myself won the company law prize based on this logic. And when it comes to FE1 and when I give FE1 seminars, I always tell people, have a strategy when it comes to the subject you are studying. And for company law, it is quite simply look at past exam questions. And also have an understanding of the rationale of company law, which is to protect creditors first and foremost. And also to maintain capital. You don't want capital dwindling by the directors for unscrupulous reasons. So usually there will be, the first question I would say to cover would be separate legal personality being a cornerstone principle of company law. I mean, there will usually be questions such as there is a sole trader, for example, Law Hero. Could you advise Law Hero around the advantages and disadvantages of incorporation? There might also be a question around, could you explain the liability for parent companies for their subsidiaries? AKA he's asking about the exceptions or the piercing of the corporate veil to separate legal personality, for example, agency or single economic entity. And when he asks you these specific areas, you need to know the case law for those specific areas. So that would be my first point. For example, there is one thing Tom Courtney says here, which is the first question on whether corporate personality might be set aside and liability visited on a holding company for the acts and omissions of a sub was particularly badly answered. So even though separate legal personality is quite an easy area, people actually don't study it very well, which is a shame because it is the cornerstone of company law. It's like learning negligence in tort or you know, like mens rea and actus reus in criminal law, it's like a building block to the rest of the course. And like if you look in terms of directors and shares, none of those would be possible if it wasn't for separate separate legal personality. So my first piece of advice is to study separate legal personality well, and don't take it for granted at all. It's rarely not been asked. I think maybe once in the last few years it hasn't been asked, but yeah, I would definitely bank it, and also I would start with it because it's quite a nice topic. The other thing he says is very few candidates attempted question 2 concerning how members can sanction a course of action, but those who did so marked well overall. So how members sanction a course of action is also, I would say, pivotal to company law, because the members of the company are the ultimate owners. And even though under section 158, directors have a delegated responsibility to manage the day-to-day affairs of the companies, there are certain times when a member needs to take back control. And this question asks, what are the mechanisms by which a member of a company can take control? Of course, the first one is a resolution passed at a general meeting of the company, duly convened, whether physical or virtually. And as we know, because of the COVID-19 Miscellaneous Provisions Act 2020 extension, which now extends to the 31st of this. So Saki hiccups in his sleep, which was extended to the 31st of December 2022, we know that having virtual AGM is allowed. The second way is by unanimous written resolution and written decisions. And the third one is by unanimous informal agreement, which is the Buchanan principle. All of these are set out in my notes. The third one, as I said, directors have a delegated responsibility under section 158. A lot of people don't know section 158 well. I mean, this was asked in October 2021. And I mean, the whole provision around section 158 simply means that there is a reservation of power to members, you know, and the whole power under section 158 is restricted by it may be restricted by the Constitution, by your Companies Act, like for example if you're doing something illegal or in breach of company law. And then the third one is directions and resolutions, which, you know, come from the shareholders. Let's go back to what he said. Even the commonly occurring question on restriction was on the whole badly answered. And you can see his frustration coming out here. So this is point number 4. There will always be a director who has breached his or her duties and will be facing a section 819, and more than likely you will have to call out the breach under section 228. You will have to talk about section 819, that it's a 5-year restriction and what that actually means in practice. And then you'll have to talk about how you defend a section 819. And then you'll have to talk about the different breaches, like what did the director do? What, did they fail to file books and records? Were they double jobbing, for example, which comes up a lot? And then you'll have to know the different types of directors. So, you know, would it be a defense to say this is, you know, not all the directors should be restricted? Is this a de facto director? Is it a shadow director? Is it a passive director? You'll have to know all these different things. And this is a section of my ebook which is very well put together, and the case law is very, very clear. I've talked about this many times. So that would, like director's duties in section 819, they would cover 2. So at this stage we're up to, so what have I said? Separate legal personality. I would say decisions of members and directors' delegated authority would be the second. The third one would be directors' duties. The fourth one be restricting directors. The fifth one, which always comes up, is the director's discretion to decline to transfer shares under section 95. asked every single year. It's no big deal. And again, there are some nuances around that. For example, there may be a claim, for example, if somebody receives the shares by way of probate, they won't be able to claim under section 212 because you have to be a member. But under section 2128, a personal representative of a deceased member is entitled to claim. Section 212 is also pivotal. It's a sword of a member to have a court sanction directors for oppressive behavior or other members. And it is a way for minority shareholders to be protected. So, I mean, those are 6 or 7 of the big areas I have called out. Let me just check March 2021. So yeah, number 8 would be corporate capacity and ultra vires. Again, some people still seem to have a misunderstanding around the fact that ultra vires still does apply to every company other than the company limited by shares. But the issue is that in practice, the Act and your constitution mitigate the presence of ultra vires nowadays. So it's basically become moot, but it still does exist. Director's duty was asked again, section 819 was asked again, and I suppose the final big area of company law we can talk about would be in relation to charges and receivers. So the first one would be in relation to charges quite generally. So sometimes you may be asked around how a floating charge will crystallize, how a fixed charge is registered. Those were 2 questions asked in March 2021. And then relating to charges would be receivers. For some reason, a company has failed in its financial obligations under a loan, and the receiver is, as the word implies, the receiver of the charged asset and has certain obligations to sell that asset and recoup the value for the lender. Other kind of lesser known areas in the company law exam that are asked sometimes would be, for example, was question 7, March 2021, the section 31, statutory contract of a most sacred character. Members of a company are bound by the constitution as between themselves. And the other one I would say is probably examinership. Those would be the kind of, and liquidation is rarely asked substantively. So I would say that they are the broad areas of company law you should know for the exam. I need to keep this video under 15 minutes, so that's what I would say. I hope you enjoyed it. Please check out the other videos, and I'll see you in the next one.